May, I had the opportunity, along with some other women, to give a witness statement for a mock CEDAW hearing led by Dr. Jocelyn Scott, and it was through the University of New South Wales. For those that may not be aware, CEDAW stands for the Convention on the Elimination of All Forms of Discrimination Against Women. It's an international human rights instrument from the United Nations, and Australia is a signatory to it. It's also ratified within our Federal Sex Discrimination Act. With Australia's upcoming 9th periodic report at CEDAW's 86th session, the statements and supporting evidence from women were prepared to be used in an NGO submission to the CEDAW committee. My statement and evidence related to Article 2 of CEDAW as it pertains to incarcerated women and girls. Article 2 calls for states to condemn discrimination against women in all its forms and calls for states to embody the principle of the equality of men and women in their national constitutions and other legislation, to adopt appropriate legislative measures prohibiting all discrimination against women, to establish legal protections of the rights of women on an equal basis with men, and to ensure the effective protection of women against any act of discrimination, to refrain from engaging in any act or practice of discrimination against women, including public authorities and institutions, to take all appropriate measures to eliminate discrimination against women by any person, organization, or enterprise, to take all appropriate measures, including legislation, to modify or abolish existing laws, regulations, customs, and practices which constitute discrimination against women, and finally, to repeal all national penal provisions which constitute discrimination against women. I took this opportunity to present a comprehensive witness statement built from a unique combination of knowledge and experience. I was incarcerated in the United States of America at the ages of 16 and 17 in various jails and 2 prisons. I now lead the Australian peak body for the sex-based rights of incarcerated girls and women, Single Sex Prisons Australia. And I'm also the founder of the International Network for Incarcerated Girls and Women, which, as Janet was saying earlier, includes advocates from the UK, Ireland, Canada, and the US. Through activism, liaising with media, and engaging in advocacy and political lobbying, over the last several years, I've become connected with many people and organizations within different communities and levels of government. So I appreciated and valued the opportunity to lend my knowledge and experience to this important CEDAW project. Women that participated in this mock hearing were given a list of questions to answer and give evidence to. And for tonight's presentation, I'll go through a few of those. I was asked, how has Australia's implementation of its obligations pursuant to CEDAW improved since it first adopted CEDAW in 1980, and what has worsened? Within my answer to this question, I included numerous examples of how, unfortunately, in relation to incarcerated women, little has improved and much has worsened in the last 50 years. There's a little list on the screen of some of those areas, just some where it has either not improved at all or has noticeably worsened. In relation to strip searches, there is an overwhelming amount of research that shows female prisoners experience strip searches as a form of sexual violence or coercion. Outside of the prisoner-prison officer relationship, the coerced removal of clothes would constitute sexual assault. We know why women experience strip searches as a form of sexual violence. Quote, as a population with one of the highest rates of physical and sexual victimization, women in prison can find the process of strip searching especially traumatizing. In many ways, strip searches replicate the dynamics of abuse by incorporating elements of coercion, degradation, and invasion of personal privacy. For women who have been victims of abuse, the process can be unbearable as they are once again placed in a position of helplessness and lack of control. That quote is from the Women in Prison Advocacy Network. Significantly, it has been found that a reduction in strip searching at select women's prisons did not lead to an influx of drugs. And we know that the overwhelming majority of strip searches are done out of routine and not in response to safety or security concerns. Despite all of this, in Australia, strip searching of women prisoners continues and is a very serious problem. Hundreds of incarcerated women are being invasively searched every year, and some of these women are being searched multiple times. New data reveals that 841 strip searches of women in Tasmanian prisons took place in a 7-month period, with only 3 filling the search. The figures obtained by the Human Rights Law Centre under a right to information request revealed the data for the period between October 2020 and April 2021. The documents show that only 3 searches turned up concealed items, and those items were pain medication, tobacco in a lighter, and tobacco in matchsticks. The Human Rights Law Centre says Tasmanian prison searches are conducted too frequently and not in line with international standards. In New South Wales, the problem is dire. The Human Rights Law Centre submitted a Freedom of Information request to Corrective Services New South Wales for the records of strip searches on women in prison between that same time period of October 2020 and April 2021. In response, the agency said there are no registers or logbooks where those searches are recorded. Considering what is known about the extensive and complex histories of abuse and mental health issues for women prisoners, and considering what we know about how ineffective strip searches are and how women experience strip searches, the fact that women prisoners are strip searched is genuinely unforgivable. Another area which has not improved is incarceration rates of women in Australia. In my witness statement, I provided a snapshot of incarceration rates around the time that CEDAW was ratified by Australia, with the most recent time period possible. In the state of Victoria, in 1988, there were 116 women in prison, an increase of 446% from the mid-70s. Male imprisonment had increased only 11% over this same period of time, so 446% compared to 11. It is noted that Australia-wide female incarceration increased by 217% during this time. This increase was not attributable to rising crime rate. A 2020 Australian Institute of Health and Welfare report states that the female prison population increased 64% between 2009 and 2019, while the male prison population grew by 45%. Furthermore, 36% of women in prison had a maximum security rating, compared with 31% of men, although they did not commit the same level of serious offenses, nowhere near it. Women were 40 times more likely to be in prison for fine default than men were, for instance. These trends echo international growth in the rate of women being incarcerated. The number of females in prisons worldwide increased by 53% between mid-2000 and mid-2016. The growth in the female prison population cannot be explained by global population growth or total prison population growth. However, data from the Australian Bureau of Statistics states that from the 30th of June 2021 to the 30th of June 2022, female prisoners decreased by 10%. Now, this decrease could be correlated to legislation to end imprisonment for unpaid fines, or it could be related to COVID-19 lockdowns and other associated restrictions on movement and normal activity during that time period, but that is all speculation of mine. Another area that has worsened is privatization. Australia has the highest proportion of inmates in private prisons of any nation, at around 17%. Heavy reliance on and investment in private prisons has failed to achieve positive community outcomes, and this is proven by increasing incarceration rate around Australia since the 1980s. The Australian prison system is being increasingly privatized, and this has direct implications on reoffending rate, as private providers are being made responsible for recidivism outcomes, despite the fact that they may also retain incentives to keep people in prison. Another question I answered was, how has Australia's implementation of its obligations pursuant to CEDAW improved since its last report in 2018 what has improved for women over the past 5 years, and what has worsened. This was very interesting for me due to the email and letter exchanges I've had with different state and federal politicians. There is a list of issues and questions for our country's representatives to answer prior to the 9th periodic report for CEDAW. One of those issues in particular that should be reported on says women's conditions of detention and whether they are in conformity with the United Nations rules for the treatment of women prisoners and non-custodial measures for women offenders, which is also known as the Bangkok Rules, and the United Nations Standard Minimum Rules for the treatment of prisoners, which is also known as the Nelson Mandela Rules. So it's saying you need to report on whether or not women's prisons conditions meet the standards set within the Bangkok Rules and Nelson Mandela Rules. In correspondence with state and federal politicians from over the last few years, elected leaders of Australia have stated that states are not bound by or required to meet standards set forth in the Bangkok Rules or the Nelson Mandela Rules. They instead point to the 7 core UN treaties to which Australia is a signatory, all of which are dangerously inadequate regarding the rights of women prisoners. So in my statement, I gladly outed the Australian federal and state government for essentially snubbing the Nelson Mandela Rules and Bangkok Rules, despite the fact that they are important human rights instruments, and despite the fact that there is a specific directive to have conditions of women's prisons meet standards set within those human rights instruments. An area which has continued to worsen and worsened in ways that we thought we would never see are breaches of women's human rights while incarcerated. Every state in Australia has at least one corrective services policy or state legislation that breaches the provisions within the Bangkok Rules, the Nelson Mandela Rules, as well as CEDAW and by extension our Sex Discrimination Act, by allowing natal men to be housed as and with natal women. This brings us to the core of my witness statement and evidence that I submitted. Discrimination against women, what CEDAW exists to eliminate. I saw an opportunity here to not only bring the attention of an international committee to the individual policies and practices that constitute discrimination against women prisoners, but also make a serious argument for legally defining the imprisonment of women and girls as a form of discrimination. I believe incarcerating women is an act of discrimination against women. Considering what we know about the number of incarcerated women suffering from traumatic brain injury, post-traumatic and complex post-traumatic stress disorder, depression, poor mental health, and how many of those women have histories of sexual and physical violence and child sexual assault at the hands of men, the act of sentencing women to serve time in a penal facility, and the act of incarcerating women are forms of direct discrimination, which other forms of direct and indirect discrimination stem from. Women prisoners also suffer ongoing forms of discrimination, and this all turns into compounding discrimination. I'll explain this a little bit more. The direct discrimination of arrest and incarceration, sentencing and incarceration occur, and then other forms of direct discrimination occur. For example, strip searches. And indirect forms of discrimination occur, for example, loss of parental rights. Ongoing discrimination occurs post-release from incarceration. We know that incarcerated women struggle more than incarcerated men when re-entering society and their community post-release. They face a lot more stigma. For example, ex-incarcerated women suffer more isolation from family and friends, and they have more trouble finding employment. Loss of custody of children, trouble finding employment, trouble finding stable housing, having to enter unhealthy relationships, and many other barriers confront women upon exiting prison. These compounding issues feed the problem of rising recidivism rates for Australian women. I was able to finish my statement by making recommendations which will hopefully be considered by the CEDAW committee. Because national legislation is severely lacking in efficient protections for the privacy, dignity, safety, and sex-based rights of women prisoners, and because CEDAW is, in and of itself, inadequate regarding women prisoners, I recommended that Australia ratify and implement the Universal Declaration on the Rights of Incarcerated Girls and Women, which is a formal document that I worked on for a couple of years and collaborated with Heather Mason and Amy Chikawa, two ex-imprisoned women and staunch advocates for women prisoners, and other amazing women in Ireland and the US. Other recommendations I made included for Australia to ratify the Nelson Mandela rules, to legislate a ban on strip searching and body cavity searches of women prisoners, and legislate the use of electric body scanning technology, to legislate the requirement of states to overhaul penal systems to become more similar to open or progressive prison systems, to prioritize preserving the mother-baby bond above active sentences for women, to undertake an urgent inquiry into the circumstances of all women in prison who have been involved in violence toward or the death of a partner or former partner. As a matter of urgency, review how the tightening of bail laws, use of mandatory sentencing, and the shift for longer sentences for drug offenses are all affecting the rise in incarceration rates of Australian women, and to define the incarceration of women and girls as a form of discrimination, often incorporating violence, that must be phased out as far as is practical and possible. I'll wrap up by adding that Single Sex Prisons Australia made a comprehensive submission to the Australian Human Rights Framework inquiry, where I again advocated for less women to be imprisoned, for the imprisonment of women to be considered an act of discrimination, and for the rights of women prisoners and other vulnerable women to be better represented in national legislation. If you would like to read my CEDAW witness statement in full, I'll share the link once my presentation ends, and I'll also share the link to the Universal Declaration, which you are very encouraged to send to all Australian politicians and to the United Nations. Thank you.